Good evening, everyone. We'll just wait for a couple of minutes for our other guests to join as well, and then we'll start in a minute or so. Good evening, everyone. Yeah, just wanting to make sure that my audio is clear. If you can raise your hand to let me know, intimate that I'm clear, loud and clear, so that we can go forward. Yeah, yeah. Thank you, Neha. Thank you. Thanks, everybody. Yeah. So a very good evening, ladies and gentlemen. Welcome to this webinar on how to identify your company's intellectual property. My name is Charles, and I'll be the host for this evening. And wanting to thank everyone who has joined, and also we look forward to see other people join soon as well. And also wanting to thank all the people, those who are viewing this webinar from YouTube and other social media platforms as well. Ladies and gentlemen, before we delve deep in the topic, let me introduce briefly about Vakil Search, who we are. Vakil Search is India's largest legal, tax, and compliance service platform. Be it your documentation or registration, or tax filing or returns, our company experts, chartered accountants, company secretaries, all of them are there just a call away. And you can see all this information in the description, and also we'll be sharing all the information right throughout the webinar. And also, by the way, we have two amazing surprises that is kept for all the attendees, which I'll be sharing, revealing in a while, maybe at the end of the webinar. So let me set the agenda for the meeting. The primary discussion will be on identifying IP, intellectual property and its types. Followed by that, we will have a brief Q&A session with Mr. Karan. And keep all your questions ready. You can write it or you can shoot us in the comment section. So Karan will take up the questions at the end of the session, and it will be primarily a conversational basis. And our key speaker for this evening is Mr. Karan Agarwal, a senior IP advocate at Vakil Search, an expert in intellectual property laws. Karan specializes in trademark, patent, copyright, and design. He has helped numerous startups and established businesses protect their intellectual property and navigate complex legal issues, and has extensive experience in advising business. So without taking any much time, may I present to you Mr. Karan. Over to you.
Hi, Charles. Thank you for the introduction. And welcome everybody who has joined this and will be joining in the coming few minutes. So, it's indeed a good session or a good topic that we're going to discuss today as to how to identify intellectual property rights. So, in the coming period, each and everybody, every business is coming upon a new idea. Each business is based upon a very small idea. You find a problem in the current business, you find the problem in a current scenario or in the current market, and you solve around it. That business idea becomes your entire business, your identity. You need to find a way of how to protect it. You need to ensure that you are one in the market. You need to make sure there are not somebody who copies your idea and runs an identical business. To do that, you need to make sure that your idea, your business proposition is legally protected. That's where intellectual property rights come into being. To give you a brief, what is intellectual property? Intellectual property is simply any idea, any idea based how you can protect any idea. The ideas can be protected in different formats. It can be protected as a trademark, as a copyright, as a patent, as a design. There is something called geographical indications, plant and varieties, trade secrets. But again, there are four major bifurcations which normally businesses need to protect. Firstly is trademark, copyright, patent, and design. Each business has some of the other kind of IPs involved in their business. The most important crux and aspect that you need to see is how to identify. In the current time, people are starting off their business, they know, okay, I need to apply for a brand name, I need to apply for a trademark. But after that, that's just not it. There are many other IPs that you need to learn to protect so that you are one in the market. So that is going to be our agenda to discuss how you can identify. If you come up with issues, you are starting a business, you apply for a trademark. Okay, is trademark is enough? Do you need to protect anything else? If somebody else has taken up your trademark, is what to do in those circumstances? To answer all these questions, you need to identify. That is going to be the main agenda of today's discussion.
Uh, Karan, like as you said right now, one of the things, like whether it is a startup or an established business, the way how you present it right now sounds like this intellectual property is something very serious in terms of its consideration, because it can make or it can break a company. So if you can help us understand, like what is a pro and a con of having or not having the intellectual property identification?
Sure, Charles. See, very rightly said. In the current times, as I started off with, idea is the entire thing. You have the right idea, your business will go booms. You don't have it, it would flop out. But to make sure that your idea is, you are the one and the only person in the market, you have to make sure that is protected. For example, you launch a unique kind of a business, you launch a unique tech. You didn't apply for the patent or a proper protection of it. Your competitors in the market are ready to grab any opportunity to see any specific thing that they can involve into. So you launch a unique idea, you did an entire R&D, but you didn't protect the IP. After 2 weeks that you have launched, somebody already knows, okay, this idea is picking it up, and they will launch a similar kind of a product. They will put some marketing around it, and they will catch up that idea. So your entire idea, the entire business idea for on which you worked upon, you didn't get it protected, you will lose the entire revenue because you didn't apply for a requisite IP to protect this. So that is why you can have not only have a revenue loss, your entire efforts that you spend working upon the manpower, all those will be lost. So that is why it is very important. If you have protected it, yes, if you have protected it, you will be like in a crowd of millions of, for example, if you have created tech-based product and millions of tech-based product, you will be one in the market. You can own the market for the tech that you have created.
Okay, Karan. So, like, what you're trying to say is intellectual property, meaning it refers to the legal rights associated to the, for example, if it is, I'm in an apparel industry or any industry, that the very work, the design, the concept, even the name, that all can be protected from the unauthorized use. That's what you're trying to say.
Exactly, Charles. Again, I will
Yeah.
give you like one example around it.
Yeah.
For example, like this is a shirt that I'm wearing. Again, there are various Apple-based brands there in the market. There's Raymond's, there is a number of brands. I'm just picking it. So in each and every product, there is some other kind of IP involved. Firstly, like the brand name, Raymond's, CRM, whatever. You have to make sure you have to grasp a very catchy brand name. You have to apply for a trademark or a brand name which is unique, which stays in the mind. You don't have to apply for a very generic name. In the current time, one of the most common or very simple mistake people do when launching, they use a very generic term which is very descriptive of the goods. Don't use that. Don't use that. You should apply for something which is very unique and which remains catchy. Use slogans, Dil Mange More, and many other things. People remember slogans. People remember slogans. Use that. Have a unique packagings. Have a unique packagings, color markings around it. All those things. You apply the color packaging or the unique packaging that you have as a label trademark, so that you can protect. So as I said, started with the logo on the brand name. You have to protect the design of the shirt. If you have a stripe, if you have floral designs on the shirts, or any kind of product design that you have, you can apply for the design registration for the same. Currently, people are not aware what is design registration. They simply say, okay, again, each and every tangible product which you have designed, or any product, any tangible product which has a unique design, you can apply for the design registration for the same. There are patents involved in it. If you have a unique shirt or something which is like electronically operated and which adjusts to your body, or there's a fan built inside a jacket or something, there are people coming around with such kind of products. If you have something like that, you can apply for the patent for the same. So it's not like patent is only applicable on big machineries or something. Even on the smallest products such as a shoes or a shirt or a tie or a tube, it can be patent can be applied for anything if it is solving a problem.
Karan, right now, while in the discussion, like you were saying something about the concept of class in intellectual property, right? Like, so can you
Yes.
explain a little more on that?
Okay. See, when you apply a trademark, so like trademark is one of the most common intellectual property anybody is apply with. You're starting a business, you will have a unique brand name. So when you apply for a trademark, as per laws in India and internationally, they have bifurcated any and all kind of businesses in around 45 different classes. So like class 1 to class 34 talks about product-based industries. Class 35 to class 45 talks about service-based industries. So any kind of product, for example, cosmetics fall in class 3, pharmaceuticals-based industries fall in class 5, then like apparels in class 25, food products in 29, 30, alcohol in 33, and food industry in restaurant industry in 43. So again, they have bifurcated any and all kind of products that is possible in all these specific industries. So when you are applying for a trademark, you have to be very sure to apply the trademark in the right class. Many times we see that people they usually end up they want to apply for a trademark, and they end up applying in an unrelated sector. So at the later point of time, at the stage of the hearing, they might have some objections. They might be not be able to show in that they're actually using the trademark for the said services. So the trademark might not proceed. So hence, to prevent those instances, yes, you have to be very sure as to what is the class that you are applying in. You have to get a lawyer, take an advice of a lawyer or who has been in the IP practice for long to determine what is the right class that you need to apply. And accordingly, you have to apply the trademark.
So quick question before I jump into the next one, Karan. So there is one product that can be in multiple classes as well?
Yes, it's always, again, when you're launching a business, there are many, what do you say, classes which are overlapping. Or when you're launching a products, when you're starting a business, you might not be having one product, you might be having 10 products, but over related. For example, you are into yarns, threads, apparels, footwears, all these, but they will have different classes. You have bags, you might be into all these products, so the bags will come under like class 18. You have yarns and threads which will come into 24. You are into shirts and pants or footwear will come in class 25. So anybody who's starting their business, they don't start with one or two products. They start with many products. So you have to apply in different classes accordingly.
Thanks, Karan. So my next important question would be for the benefit of the guest all over here and people those who are viewing right now, can you help us by giving practical examples? Maybe something that we see day to day and how they are protected, or give us some practical examples.
Okay, okay. So again, to give you a practical example, consider a cafe coffee day. So it's a restaurant-based industry. So considering if you are starting a cloud kitchen, or if you are starting any kind of restaurant-based business, or you are selling some kind of food products from your home, for all those, firstly, you need to have a brand name. You need to have a name. So you might start with, you pick up a name, you create a unique designing around it, and you create a logo around it. So firstly, you have to create a unique logo. You have to get a brand name which is catchy. You apply for the trademark for the same. For all the, when you started putting up posts, if you have created a unique dish, so if you have found a unique dish, or you have created a unique recipe which has not been found till date, you can even go ahead and apply for a recipe patent. So there's something called recipe patent. People think, okay, you have to apply for a patent for machinery. No, even for basics, something as small as recipes, if you have come up with something crazy which has not been created as of date across the world, you can apply for a recipe patent. If you are writing a cookery book, so you can apply for the copyright of the entire book that you are creating. If you are creating a website for selling your products online, so the entire coding of the website or the mobile application that you are creating, all these are coding based products. Codings you have to protect through copyright applications. So like as I started with, basically trademark is the brand name, copyright, any kind of content which you can put on a hard paper or on a soft copy. You apply for a copyright for the same. Patent any kind of unique product altogether that you have created, any kind of unique machinery, or for in the food industry, any kind of unique recipe, you apply for the patent for the same. With respect to design registration in food industries, if you are having any kind of packed bottle or something of any jar, for example, a jam jar that you are along with that food industry you are selling, you can apply the unique shape of the bottle of the jam jar. That unique shape of the bottle, you can apply it as a design registration. So again, if you're in the restaurant industry and you're launching a jam, you will have to apply for a separate class then. Food industry come in class 40, restaurant industry come in class 43. If you're launching jam, it will come in class 2930. So yes, so this is how different aspects you have to protect, even if it is just launching in one industry.
Okay, thanks, Karan. I'm going to read something very interesting and I'm going to take a question from there. It goes and says like this, that the industry size of Indian IT sector, okay, as of 2023, is estimated to be around $194 billion. And the industry has been growing at a compound annual growth rate of 7% in the past few years. Now, help us understand how from the IT industry or a software industry, that intellectual property can be identified and taken forward.
Charles very correctly said. Again, the IT industry is the most growing industry, and the current time it is going to be the lead industry in the current market. So again, like, what mobile phone do you have?
I use the iPhone.
Okay, so ditto. So like, even I have an iPhone here with me. So if you just see this product, it is one of a product of an IT industry, Apple company. So again, firstly, there are various things that are there that you need to protect. If you are creating anything on a mobile phone or a camera based, or you're creating a software. So for first example, if you are creating a product base, the first thing that you see is the logo. You have to make sure that you apply for the logo as your trademark. If you have the name that is Apple, you apply for the brand name per se, Apple as a trademark. You have a unique shape of the mobile phone. Each and every Apple phone has a unique different shape. You apply for the design registration of the same. The internal mechanism, if you are creating a unique camera, if you are creating a unique watch, which again, this fast track watch, if you have a watch which has a unique mechanism inside it, it's solving an issue which has not been solved before. It's solving a problem which is not, it's bringing a technology, it's creating a hologram which is popping out or something. which has not been solved before. It's a flying watch, or it's a flying mobile phone. So all these things you can apply for a patent around the same. All these people, they are launching different kind of applications. Each of the applications that you can see on your phones, they have a unique coding. They have a unique coding. They are games. They have a unique coding. You need to apply for the codings as copyright applications. So all the codings of the software, they will come under copyright. The brand name will come as a trademark registration. All the contents, the videos, all the pictures that you are launching, any kind of marketing that you're doing through videos, or any any kind of marketing that you're doing through pictures, all those you need to apply for copyright. For design, as I said, the shape.
So the hardware and the software lays independently of the intellectual property. But can you help us like with some classes numbers, since you pointed out in the earlier, one product can be registered on multiple classes. So where does this IT and software industry stands in terms of classes?
Okay, so like any kind of electronic devices like mobile phone, cameras, or mobile applications, if any product based on these will come under class 9. If you are providing services, technology or IT based services, they will come under class 45. If you are putting all these services and selling it on some e-commerce platform or something, then they will have to additionally apply in class 35 also. So these are the major classes that you need to apply.
Okay. And Karan, this healthcare and cosmetic industry in India also growing rapidly, especially post-COVID, because there is a serious amount of investment that is being made in these two industries, especially the healthcare. Can you help us or throw more light on that as well in terms of intellectual property?
Sure, Charles. As again rightly said, during the COVID period, many things such as hand wash or hand cleansers, all those became a big boom. And the medical industry is currently going at a very fast pace. But again, for example, if we take like this hand sanitizer, as simple as this hand sanitizer, you can see the shape of this bottle. It has these grooves in the middle. So any unique shape of any bottle or any medicine that you create, or any kind of medical based products or a cosmetic based products, even I'm considering cosmetics also, any unique shape of a bottle that you have, that shape can be protected as a design registration. You have a unique brand name mentioned in a specific font with lines on top, you have to apply for that as a trademark registration. All the content that you see here and the back, you can apply the entire packaging as a labeled trademark. So again, many times, many people came up with unique packaging or the unique color combination, and you want to ensure, okay, I am the only one person who is using this kind of color combinations and this way of writing or designing of your packaging. You want to be the one because that is catchy that you have created. You need to apply for the entire label of the product as label trademark, not just the brand name, Lakme or something, or whatever that brand name you come up, the entire packaging. Even the liquid that is there in a shampoo bottle. So if the composition of the product is unique, if the formulation, the chemicals that you put or the other contents is unique, which has not been founded of, and it is solving a major problem which has not been solved before, you can even go ahead and apply for the patent for the same. All the content that you're writing about your product, everybody in the current time, they're launching the product on e-commerce platform. They're listing out the product. They're writing huge content about your product, each and every one. You need to make sure to apply for the content protection of the same. It's a very common perception or very common issue that the current industry is facing are two things. On e-commerce platforms, each and everybody is going on e-commerce platforms and selling the products. And the two things, firstly, people get a professional photographer and click unique images of the product and post it. Secondly, some people get a unique content writer and write the entire content. People simply copy those images and those content and create their own pages and start selling their product. So to make sure that if anybody copies those, you can protect it by getting a copyright registration for the same. So
and also, can you tell us the class as well for this healthcare and cosmetic number, I mean?
Okay, so again, for like cosmetics, it's class 3. For pharmaceutical based products, it's class 5. If you are having any medical or surgical based equipments products, then it will come under class 10 specifically.
Okay. Now, I have two more important things that I would like to ask. One is our day-to-day products like dairy products, Coke or biscuits. It's a very common thing. That one. To the polar opposite of luxury, like leather bags and so throw some light over there.
See, you're again with respect to the like any day grocery products, each and everybody would be seeing in the kitchen that the products that they have, the biscuits that you're having or the chocolates that you're eating. Each of them has again a unique packaging or again a unique way of representation. So, like for example, this as simple as this chocolate that we have of Cadbury Dairy Milk. You see the way the fonting that they have written of Cadbury and the way that they are representing dairy milk, all this has been applied as trademark patent to make sure that this is unique. They have even applied for the entire packaging, this color packaging that they have, and the way that they're placing all the content on the top, whatever they're writing. This entire thing, all the brands, all the big brands at least, they are applying for the entire packaging as labeled trademark. With respect to again for the patent aspect, there are few big brands. Even I think there are few big brands who have even went ahead and even they have a unique recipe. As I said initially, they have a unique recipe of making these chocolates or making some products. They are applied for the patent for the same so that nobody can create similar kind of chocolate like they have created. Everybody sitting here would have had at some point of time the Toblerone chocolate. So it's a triangle shaped chocolate that you have. It's a unique design. You can apply for even the design of the shape of the chocolate. So any product that has a shape from biscuit to a noodle shape that you have, or any the Parle-G biscuit shape that you see with Parle written on top of it, you can apply for the design registration for the same too. So yes, in anything in the food industry, yes, this is what you have to apply. But again, Charles, your side on anything you said additionally on the leather and bags industry. So again, with respect to bags or leather-based products, they have an absolutely separate, it's an absolutely different segment altogether. So with respect to it, they have a different kind of trademarking requirement. They each and every bag, each and every purse, they have a unique designing of their own. And many designers have set up their shops across India and every home and every building. There's a unique designers coming up with a unique shape of a purse or a bag. To all those designers, all those persons who are coming up, what you have to make sure is whatever design that you're coming up, get a design institution for this. Make it unique.
Okay. So Karan, if this entire webinar to be summed up, maybe I would say, if you could have put it in 3 points, if I ask this question, what are some of the benefits of protecting my intellectual property? If you would give me 3 points, what that would be?
See, first point, you want to have, whenever you are actually going into business, you're looking for funding. First is IP valuation. You should be able to value your business through your IP. So whenever you're pitching, it's a very common thing people are saying when you're going to the investors, they ask you how well protected is your IP. The reason they're asking you is this: they want to know what is your exclusivity in the market. How is your brand rightly protected? What are the chances that somebody end might come up? To ensure that protection, you need to do it. To ensure that you can pitch it out, you can show that okay, yes, I'm the only one in the industry who have this right. You need to have a trademark or an IP registration for the same. Second aspect, to if you get up or if you get stuck up any kind of legal tussle, if you get stuck in any kind of legal tussle, so you need to have a legal document to showcase, yes, I have a trademark registration, yes, I have a patent exclusivity over this right, and nobody can take that from me, to maintain your exclusivity over the same. Hence, you need to apply for the registration for it.
So Karan, you're saying, one, it increases the value of my business and helps to secure like investment or any other thing that I can go forward with my business. Second, it gives me legal protection. So if does someone infringe my design or thing, that will protects me from that. And third, it creates a unique identity in the market, being exclusive, that I'm not the same. That's the three benefits that you're saying when you go and protect your intellectual property.
Exactly.
Okay. Thank you. Thank you so much, Karan. Now, I just wanted to take up some quick question from the floor before we take up maybe another section of a question. So if anybody has in the meeting that wanted to ask Karan some question, you can drop in your question there in the chat box so that we can take up that question. So in the meantime, when the guests are preparing their question, uh, I just wanted to ask you this question about, there's something called identical or similar trademark, something that we stand. If I have a business, I also have somebody else is doing the business in my own neighborhood, who we both are running into the same kind of business where a same particular design or something that we have. So how can we go forward in that?
See, the trademark law is very clear on the aspect that when you apply for a trademark, you have to do a basic trademark search. Trademark search clarifies that there is no similar trademark in existence. There is nobody who has applied for an identical or a similar name as you have. Identical is, for example, you have your brand name is Charles, and there is somebody who has copied exactly Charles. That is identical trademark. Somebody has taken up an identical trademark of yours, or somebody comes up with a trademark Charlie's Angels or something like that. If somebody come up with that, that is a similar trademark somebody has come up with. So
Okay.
any use of such kind of an instances, that is called trademark infringement. People should not be doing it. Even when anybody who is here, who has joined, has done or even adopted or are aware that somebody has actually started copying their brand names or created a similar brand name, some of your friends or your colleagues have created a similar brand name, that falls under a clear case of trademark infringement. And you should take proper actions against these infringers by appropriate legal proceedings, be it legal notice, opposition, infringement proceedings in court. There are various ways. But yes, that's something that falls under trademark infringement and should not be done, Charles.
Thanks, Karan. Karan, we have a question from the floor asked by Mr. Charan Verma. Can logo and brand name be trademark in the same application?
Yes, yes. So again, what is, for example, what is brand name? And what is brand name? For example, Maruti. Maruti is the basic Maruti. Maruti is the brand name. And then they have that logo. Then they have that logo, which is a designer format. That is simply a logo. So again, it is you. When you are starting a business, when you're starting a business, you can firstly, when you are applying for the trademark, you can apply it as a composite trademark. Composite trademark means which has both the logo and the wording involved in it. You can apply for the same in one go itself. But again, depending upon the way that you're going to use in your market, if you're using the logo without the wording, it is suggested to apply for the logo separately and the brand name separately.
Okay, so you're saying that composite trademark is an inclusion of the logo and the text, like I mean brand name as well,
Exactly.
right? Okay, okay. So we have one more question that comes from Mr. Joseph George. Is there any way to protect a unique business or a sales process, basically like a model? Because he is facing some issues where his employees started business copying the exact same sales model.
Okay, see, business ideas again, sales model, anybody can come up with a sales model. But again, if you have come up with a unique process of doing something, if you have come up with a unique system or a unique, you have created a unique application wherein your process is to be followed around it. And again, in such a scenarios, you can, there's a concept called concept note registration. So under copyright law, whatever unique concept that you are bringing, or if you have a unique business idea, which has a process based, you can write the entire process in detail under copyright registration. As a literary work, you can apply for the same. But again, that is one of the major aspect where I have seen when you are coming up with an idea, it should not be something generic or other person in any other industry would have come up with. To make sure when you are applying for copyright, it should be unique and out of the world. You apply it. You can get that exact concept protected under copyright. And if somebody of your employees go and use the same idea, you can initiate legal proceedings under copyright. And even copyright is like one of the strongest laws among all IPs because it has like a very clear criminal proceedings also as an option. If somebody has done copyright infringement, you can even initiate criminal infringement, and the person infringing can have and imprisonment also.
Karan, Mr. Amit has this question. For example, even before you launch something, product or a service, how does anyone know, first of all, whether he's copying or not copying? Not going to set any infringement issues.
No, sorry, Charles, I didn't get your question. Can you repeat once?
The question for him is like, before launching any product or services, how anyone know that he or she is not copying anything or not going to get infringement issues?
Got it. Got it. See, again, that is where there's a concept called search. So whenever you're launching any business, be it trademark, be it design, be it patent, everything has a concept called search. You have to do a search to check whether your IP or the concept that you're talking about is already protected by somebody or is already publicly available. For example, when you're launching a trademark, we do something called as trademark search, wherein we check the entire database of the trademark applications since ever it has been filed since 1947 to check if there is a similar trademark that has been applied by somebody or not. Similarly, if you're launching a patent, there's something called prior art search, wherein we check if there's a prior existing invention already existing, not only in India, but across the world, we check it. Similarly, for design, wherein we put in the kind of the nature of the product and we find out if a similar design or a unique product is already or a unique shape is already applied as design and registration or not. Hence, that is how you can check. You can reach out to an IP attorney who have access to all the softwares and the relevant government portals, and they can check and give you a proper report around it. Yes, you can go ahead and protect it over there.
So you're saying before even, for example, if I'm unaware of something, I can go and search for that particular product or service, get to know about it before even going forward with that particular design or product or service, whatever it may be, isn't it?
Exactly, Charles. Even I have seen people who are launching their business, they start off with around 10 to 12 different brand options. You should always have few brand options in your kitty. So whichever brand has the most easy way or the most unique, you should apply for that brand name.
Okay. Mr. Amit has a question. Amit, it would be nice if you can just explain that what that issue was in relation to graphic design packaging before we pick up the other question. While Mr. Amit is coming up with a detailed question, Mr. Jatin has a question. It's, can I add multiple class in one trademark?
Yes, there's a concept called multi-class trademark application. So whenever you're applying a trademark, as I said, there is classes, it's class from class 1 to class 45. But there is something unique called class 99 also there. So whenever you're filing a multi-class applications, you can in one trademark applications, you can apply the same trademark in 4, 10, 15, or even 45 different classes. So that aspect you can do. But there is one aspect I always suggest people not to go ahead with that, because usually when you apply for a multi-class application, it usually gets stuck at some of the other kind of objections in one or the other class. So all the other classes will also get stuck because there has been objection in one. So it's always suggested to apply separate applications in different for if you have more than one classes, because even if there is objection in one class, the other applications will move towards registration. So yeah.
Okay. Mr. Karan, actually, Amit has like series of questions. He is like, one, first he has an issue, with the bags design, the graphic design, packaging, the packing content and all. That's one thing. The second, he wants to know, like, regarding the cost implication for copyright, patent, and design registration.
Okay. So with respect to Amit, design, if you have created a unique bag design, firstly, you need to apply for the design registration ASAP. So in ASAP, as in whenever you for design registrations, it is always suggested as per law, whenever you're launching your unique design of a unique product, before you even launch it or make it public, you apply for the design registration of the same. Okay, so because again, once you launch it in the market, that design is public. The design registry or the patent office, when they actually reviews our application, they check all the portals online, they check all the public forums, and then they make the analysis that the design is unique and has not been made public. You make the design public only once you have applied for the design of the same. Okay. With respect to cost implications, again, I'm not getting the question per se. Amit, again, if you can elaborate upon the question on the cost implications. But again, yes, to what I'm understanding is, again, if you have applied for a design registration and somebody else copies your design, in that case, yes, you can initiate a design proceedings against a specific person, and you can even claim damages. You can even claim cost against that person who has infringed your design or something. With respect to costing of the, if you're applying for a design, there's a separate set of costing that you have to pay. There's a government phase that is involved, and there's a costing of the IP lawyer they will charge for filing of the design application. That is separate. But yes, these are the two costings that I can see coming on.
Mr. Karan, there is one viewer from YouTube has a question, Mr. Ashutosh. He's a software service provider, it seems. Like, what can be my IP, if any? We build CRM for retail services. That's the retail stores.
Okay. So again, if you have created a unique software, if you have created a unique software for any retail stores, you can apply for the entire coding. CRMs are completely based upon the codings. So whatever aspect of the software is unique and that you have created, and be sure anything out of open source cannot be covered in a copyright protection. So anything new that you have created in that software, you can apply for the copyright registration. You can get the entire coding. There will be a backend coding with the source code and the object code of your entire software. You need to get that. When you need to give that to the, what do you say, to your IP lawyer. They will take those up. They will get a few documentations created, the POAs and the NOCs, and with that we will fill the application. We will file it.
I'm just taking up the other questions that has just popped up from the YouTube and the other webinar places. Mr. Peter is wanting to know, can I have copyright to my video-based resources, specific to value education, life skill series? So he has series of videos based on that. So we have used licensed stock footages for that particular video. Maybe if it is a 5-minute video, I think he has used some stock footages there and the design. So can he go for the copyright for the stock videos? Licensed stock videos, yeah.
Okay. See, for it's a very common issue for anybody in the education sector. Anybody in the education sector, they are creating videos around it, and the way of providing that education, or the way of speaking, or the content that you're providing, the PPTs, the contents that you have created, you need to apply for the same, because it's a very common concept of people are doing that. Your package, you might be providing it as a package, and the people who are doing screen recording. I've recently faced a scenario if somebody has done the screen recording and posted it on the group, on a group, and the entire course that you have somebody would have taken up for one person, it is now public. So yes, for anybody in the education sector, you need to make sure whatever videos that you are creating, you need to apply for the same as cinematographic work under Copyright Act. You need to apply for the copyright registration for the same. If you have used some already copyrighted work of somebody else and some snippets of it in your video, so it is suggested to actually snip those aspects out, or remove those aspects out of your video when applying for a copyright registration. Or else, if you are planning to use it, the snippets or the whatever the aspects that you have used of somebody else's, you need to have a proper license for the same, or the proper permission for the same from the actual original creator of those snippets. If you have the same, if any objection might come up at the stage of copyright objection or something, we can even submit that NOC as a document to showcase that it's a valid use. And third aspect is, if these videos that you are creating, these educational videos, they are only for education purpose, you're not minting any per se money around it, you're not doing any ads around it, then it comes under an exception, wherein if any content is for educational purposes without any monitoring involved, and you're simply putting up on YouTube or something, you can use it without any permission also.
Okay, I see few of our viewers asked a similar line of questions of knowing the cost of the process and registration for them. I would say it would be nice, like if we could have a discussion with our IP experts, maybe they can give you a very clear amount that you are going for, which class it is, which product it is, how much will it cost. All these things can be given in detail, since these are a very specific question in relation to your products, which only after discussion we could come for a price. I believe that would be your answer as well, Karan.
Exactly, Charles. Exactly. Again, the
Okay.
kind of product, what are the brand names, what are the designs, all those things, which category it is falling under. Once we review that, all those things, only then I will be able to tell the exact government fees and all the costs involved around it.
Okay.
We can
And
take
Mr.
that.
Aditya is asking a question. That's the process and registration of design in Maharashtra for shop of educational material.
So again, be it Maharashtra, be it any states, the process is same. Across India, there is one, when you're filing for design, it is being monitored by the patent office in India. So be it Maharashtra or any other state, Tamil Nadu, Kerala, the only thing is you have to see is the process will be the same. The same documents will be required. We just need the PUA. We just need all the different, uh, the entire work that you actually want to protect, whatever the designs that you have, whatever the exact products that you want to apply as IP that you want to protect, it will be the same. Be it trademark, copyright, patent, design, it is all universal across India. It is not bifurcated on state to state basis.
Okay. Thanks, Karan. Karan, there is already like the second part of the question that I'm going to ask, it's already addressed. So first part of the question is, we as Vakil Search, do we help people identify their copyright? Do we do that?
Identify their copyright.
Identifying copyright issues, yes. Do we help them?
Okay, see, again,
Because
identifying
the question was, can you guys help with identifying copyright? That's the question Shweta was asking from the YouTube.
Okay, that is what again this session is, to self-help, that you can self-help yourself. If not, yes, again there is something called as IP due diligence that we can do. You can connect. We can connect on at a later point of time or through some link that will be shared in the group here, wherein we can have a IP due diligence of your business, wherein we can sit and visualize and check what all businesses that you have, what all, how you are working, what are the different aspects that you are doing, what are the different products that you are launching, and then we can pinpoint as to what all IPs are there in your business. That is a separate discussion, which is a detailed wherein industry specific and the kind of products that you're launching, we can help you out in identifying.
And Karan, Mr. Srinivas Rav Devisetti is asking the question.
Mhm.
For some of his products, he got third-party objection, for which he has given reply 8 months back. But he still didn't get any update from the registered jury. So still showing the objections in the web. So what to do in that particular scenario?
Okay, I can understand. So there is a some lag, or you can say some delay on the part of trademark registry. They have a huge pendency currently because they back in the COVID period was there. They have what do you say, piled up many number of matters, and there are many shifts currently going on within the IP department. So yes, I'm assuming in the next few months, uh, next 6 to 7 months are a very crucial time for the IP industry and the IP department. They are scaling up many things. They are increasing the entire workforce in the government department to process all these new things. So there are many good changes happening in the IP department. So what the basic expectation is, within the next 6 to 8 months, all the matters which have got pending or which have not been responded will be soon taken it up by the IP department. So it's simply a government process. Once it gets resolved, it will be taken up.
Okay. One last question. I'm going to pick it up, Mr. Karan. That is, can we file a reply for third-party objection after 2 months?
After 2 months, no, it's always suggested to file it within 2 months timeline. 2 months timeline is very specific. So once somebody has filed a kind of an objection or an, I think, opposition against your trademark, and the 2 months timeline start once you have received the notice from the trademark registry. So that 2 months timeline will start from then, not when they have filed it. Once you have received the notice from the trademark registry, and from that time 2 months starts. Normally, yes, it is always suggested to file it within 2 months itself. However, if there is any unique circumstances or any unique case, in that case we can file a response after 2 months by filing an IP interlocutory petition with the trademark office, requesting them to allow for condonation of delay, are giving us a permission to file even a bit of delay with a specific reason. At that point of time, it is upon the examiner or the hearing officer to examine our application and process it further.
Thank you, Mr. Karan, for taking this time and patiently answering all the questions that we have thrown at right now. And the surprise that I've been telling right at the start, that would be, we do have another 2 free webinars that is coming up in the upcoming weeks. We will be sending you all the notification and information related to this particular webinars. And we look forward to see you there in the webinar as well, the upcoming webinars. But since many of the people have specific questions that takes a prolonged discussion, we wanted to say that we wanted to give one free expert consultation to the people, those who have signed up. So you might see some of the links that would be seen in the comment section, or we would be sending you that link to your respective email IDs. You can fill in all the details there, and you will get an call back from our expert and to help you out on the issues that you're facing. Mr. Zachariah has raised his hand. He has a hand. He wants to ask something, or yeah, go ahead, Mr. Zachariah. Yeah. So we look forward to, okay, he's just wanting to appreciate for all the things that has happened so far. So thank you so much, ladies and gentlemen, for joining for this webinar on how to identify your company's intellectual property. We look forward to see you in the upcoming webinars, and one free consultation is for all available, and you'll get all the details in our upcoming mails to you. And also you can sign up in the link that we would be sharing with everyone. Thank you so much, and thanks for joining, and have an amazing and a great week ahead. Thank you, Mr. Karan, for helping us and giving us all the details about trademark and helping us understand the broad perspective of how do we identify the company's intellectual property. Thank you.
Thank you, Charles. Thank you, everyone, for joining.
Thank you, everyone. Okay, the form is already there. You can see the form there. You can click on the form below in the comment section, and you can start filling your form for your expert consultation.